you know that since 2010, state legislatures across the country have adopted over 290 new laws imposing restrictions on abortion? The first of these laws to come to the Supreme Court is in Texas. It was HB 2. You might remember Wendy Davis leading ultimately unsuccessful filibuster against this being adopted. Two provisions in HB 2 were before the Supreme Court. One said that in order for a doctor to perform an abortion, he or she had to have admitting privileges at a hospital within 30 miles. Generally, these hospitals will not give admitting privileges to the doctors. Sometimes it's because they're religiously affiliated hospitals. Often it's because the hospitals have a requirement that in order for the doctor to have admitting privileges, the doctor has to admit a minimum number of patients a year. Abortion is such a safe procedure that really the doctor to be able to admit a minimum number of patients. The other restriction said, in order for abortion to perform in a facility, the facility has surgical quality facilities. So it would meet the requirements of an ambulatory surgical facility, like corridors wide enough for 2 gurneys, HVAC facilities used in operating rooms, and the like. Before Texas adopted this law, there were 40 facilities in the state where abortion was performed. After it went briefly into effect, there were only 20 facilities left in the state where abortion was performed. Well, the Supreme Court had upheld this law. There would be 7 or 8 facilities in the whole state where abortion was performed. It would also then mean if these kind of state laws are constitutional, in places like Mississippi that enacted similar statutes, every facility where abortion was performed would be closed. On Monday, June 27th, in a 5-3 decision, the Supreme Court declared the Texas law unconstitutional. Justice Breyer wrote the opinion to the court, joined by Justices Kennedy, Ginsburg, Sotomayor. Justice Alito wrote a dissent, primarily focusing on procedural issues, joined by Justice Roberts. Justice Thomas wrote a dissent, urging the overruling of Roe v. Wade. Did you know that since coming on the Supreme Court in February 1988, only once before had Anthony Kennedy voted to strike down the restriction on abortion? That was in 1992 in Planned Parenthood versus Casey. Kennedy was the majority in striking down a part of the Pennsylvania law that required spousal notification for a married woman's abortion. I think when he first participated in an abortion case in 1989, in Webster versus Reproductive Health Services, Justice Kennedy joined with the 2 dissenters in a row, William Randolph and Byron White, in urging the overruling. So I think, in addition to striking down this law, in addition to what it means for other similar statutes, I think this case is significant for Justice Kennedy joining with the majority in striking down the law. Had he voted with Chief Justice Roberts, Alito, and Thomas, there would have been a 4-4 split, and the Fifth Circuit decision upholding the statute would have been the law. The law would have gone into effect. Justice Breyer said, the law regulating abortion is unconstitutional, but it places an undue burden on the right. This is the test from Planned Parenthood versus Casey. He then looked at these provisions and said, it's for the court, not for the legislature to decide. The law protects women's health. If the burdens on abortion are justified by the benefits of protecting women's health. The district court in this case had done extensive fact-finding. The district court concluded there was no evidence that these restrictions would protect women's health. The Fifth Circuit had reversed, saying it's for the legislature, not for the court to decide whether or not the law protects women's health. I think it's significant. The Supreme Court expressly rejected that. Justice Breyer, relying on the fact-finding by the district court, said there's no need for a doctor to have admitting privileges at a local hospital. The procedure rarely requires admitting privileges. If there are complications that are required, the doctor at the emergency room will provide treatment. There's no need for surgical level facilities. Surgical procedures aren't being performed. There's no need for corridors wide enough for 2 gurneys, because gurneys aren't used there. There's no need for HVAC facilities for operating rooms, because there's no operating rooms. You talk about all of the other medical procedures, even with greater complication rates, with similar requirements are not imposed. Justice Ginsburg wrote a short concurring opinion. He said, this decision means that all of these recently adopted statutes restricting access to abortion, the so-called targeted restriction from abortion provider laws are unconstitutional. And in fact, in just a few weeks since this decision, district courts in a number of places in the country, most recently Wisconsin and Indiana, have struck down similar statutes based on the Supreme